conservatory orders that were in force, vide a ruling dated and delivered on 13th June 2024. The court observed, and I quote, "The question which arises if this court can issue orders whose effect will be to stay the decision by the Senate to impeach the 9th respondent pending the hearing and determination of the petition. My finding is that since the Senate has already made a resolution, the court must exercise restraint and limit its intervention in the impeachment to hearing the merits of the petition. I further find that issuing conservatory orders to stay the Senate's decision will be akin to directing or interfering with another organ/arm of government in the exercise of its mandate." Close quotes. Article 165, Clause 6 and Clause 7 set out the supervisory jurisdiction of the High Court in the following terms. I quote Article 165, Clause 6 and 7 as follows. Clause 6, "The High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising a judicial or quasi-judicial function, but not over a superior court." Clause 7, "For the purposes of Clause 6, the High Court may call for the record of any proceedings before any subordinate court or person, body, or authority referred to in Clause 6, and may make any order or give any direction it considers appropriate to ensure the fair administration of justice." Close quotes, emphasis is mine. Impeachment and removal proceedings by the Senate are undoubtedly quasi-judicial in nature. Given that the Senate is not a superior court, a plain reading of Article 165, Clause 6 leads to the inescapable conclusion that the Senate, while exercising a quasi-judicial function, fits into the persons, bodies, or authorities subject to the constitutionally established supervisory jurisdiction of the High Court. Had the framers of the Constitution intended otherwise, nothing would have been simpler than to add the phrase, "or a House of Parliament," to the exclusion contained in Clause 6. Furthermore, Article 165, Clause 7 empowers the High Court, in exercise of its supervisory jurisdiction, to make any order or to give any direction as it considers appropriate towards ensuring the fair administration of justice, including staying a resolution of the Senate. The Senate is not insulated from that provision of our apex law by any article or clause of the Constitution. The doctrine of separation of powers and the principle of independence of branches of government should not be extended to run contrary to the plain reading of the Constitution. We should not lose sight of the fact that the Constitution of Kenya 2010 was the culmination of a decades-long effort by the people of Kenya to promulgate a new constitution that would be better able to check against excesses and violations of their fundamental rights and freedoms. The supervisory power of the High Court in that regard, and even over Parliament, is a critical aspect of those checks and balances and the protections built into our supreme law. This is not to say that the supervisory jurisdiction of the High Court over Parliament should not be exercised without restraint and introspection. Simply put, the mere fact that the High Court is empowered to and can supervise Parliament when one or both of the august houses performs a judicial or quasi-judicial function does not mean that it should exercise that jurisdiction in every instance and or issue interlocutory conservatory orders whose effect would be to stay the action or decision of Parliament pending the hearing and determination of the petition before the court. What should guide the High Court is whether the public interest favors the grant or refusal to grant the order sought. Both the respondent and the third interested party have once more relied on the Kisii Deputy Governor case to advance their proposition that the public interest lies in this court lifting the conservatory orders in force just as our counterpart in Nyamira did. Paragraph 79 and 80 of that ruling extensively considered the question of the public interest in the petition that was before that court. While the respondent and the third interested party sought to paraphrase those two paragraphs, they did not do that analysis justice, and thus I quote those two paragraphs verbatim. Paragraph 79 of that ruling. Turning to the third parameter for the granting of conservatory orders, which requires the court to consider public interest before granting a conservatory order, I find that the public interest in this matter tilts against the granting of the conservatory orders. I say so because it is the electorate or the people of Kisii County, through the duly elected, representatives both at County Assembly and the Senate, that considered the impeachment motion in accordance with the law and arrived at the majority decision to impeach the ninth respondent. As I've already stated in this ruling, the decision of the Senate can only be challenged during the substantive hearing of the petition and not through the granting of conservatory orders. I further find that since the office of a deputy governor is a public office that does not belong to a specific individual, it follows that once the officer is impeached, he has to give room to the next office holder unless and until such an impeachment is overturned or nullified by an order of the court. Paragraph 80 then continues, I find that in the circumstances of this case, the rights/interests of the people of Kisii County to be represented and served by a duly appointed deputy governor following the ninth respondent's impeachment far outweigh any prejudice, if any, that the applicant herein will suffer if the orders sought in the application were not granted. I close the quotes, emphasis is mine. The High Court in that matter took the position that the moment the Senate passes a resolution impeaching an office holder, that office immediately falls vacant, thus setting the stage for the filling of that vacancy within the applicable timelines. I note that the High Court sitting in Nyamira was clear that it arrived on its findings based on the particular circumstances of the case before it, as expressly stated in the paragraphs of the ruling that are quoted verbatim above. This court takes the position, as explained earlier above, that the High Court, in exercise of its supervisory jurisdiction over a quasi-judicial function of the Senate, can certainly stay an impeachment resolution of the Senate and restore the status quo ante that obtained before the passing of that impeachment resolution, pending the hearing and determination of the petition. The question, though, is, would that be in the public interest? To begin to answer that question, this court must consider the nature of conservatory orders and thereafter proceed to situate them within the question of where the public interest lies. All five parties in this matter have relied on or alluded to the Supreme Court's decision on the nature of conservatory orders in the ruling dated and delivered on 2nd April 2024 in the seminal case of Gatirau Peter Munya versus Dixon Mwenda Kithinji and two others. At paragraph 87 of the said ruling, the Supreme Court stated, and I quote, conservatory orders bear a more decided public connotation, for these are orders to ordered functioning within public agencies as authority of the court in the public interest. Conservatory orders, therefore, are not, unlike interlocutory injunctions, linked to such private party issues as the prospects of irreversible harm occurring during the pendency of the case, or a high probability of success in the applicant's case for orders of stay. Conservatory orders inherent merits of a case, having in mind the public interest, the constitutional values, the proportionate magnitude, and the priority levels attributable to relevant causes. I close the quotes. Following on from this example, proceeded to issue conservatory orders pending the hearing and determination of the gubernatorial appeal pending before it. The public interest depends on the circumstances of each case. What may be in the public interest in one matter may not be in the public interest in another matter on the same subject area due to the differences in the circumstances of each matter. The court, in determining where the public interest lies regarding conservatory orders in a case before it, can examine any number of factors or considerations, including A, what impact would the grant or refusal to grant the conservatory orders have on the public? B, how long would it take to hear and determine the petition? That is, how long would the conservatory orders likely last? C, would the grant or refusal to grant the conservatory orders sought foster constitutional principles and values? And D, are there any unique or special circumstances at issue in the matter which are undisputed, which would tilt the public interest in one way or the other? To my mind, the public interest as it applies to the people of Meru County and the wider people of Kenya would be best served by the confirmation and extension of the interim conservatory orders in place, pending the expedited hearing and determination of the petition. The refusal to confirm and extend those orders would result in a gubernatorial succession in Meru County, which in the event that the petition were to succeed in a few months' time, would have to be undone by this court and or other courts at great public cost, if at all it could be undone. That eventuality, if it were to occur, would not resonate with the Supreme Court's binding guidance in the Peter Munya ruling on the aspects of proportionate magnitude and the priority of matters. It should also be considered that in these times of austerity, prudent use of scarce resources, which is also a constitutional imperative, is all the more relevant and a greater consideration in terms of the public interest. The gubernatorial succession in the county, which would result from the petitioner's application not succeeding, would trigger events and changes that would be funded from the public purse. It is prudent to hold off on the same for a very short time and then have them either occur or not to occur based on a judgment rather than a ruling. Secondly, the public interest as it applies to a deputy office holder in the executive branch at either level of government may not be the same as it applies to the chief executive officer. The chief executive officer is the principal person tasked with conceptualizing a vision, strategies, and the consequent policies that would spur that particular unit of government towards greater heights. While certainly the deputy chief executive officer has significant constitutional and statutory powers and gravitas, they are not akin to those vested in the chief executive officer. The former receives instructions and directions from the latter, and consequently, the public interest in implications of succession in the principal office are more consequential than those in the office of the deputy. Thirdly, the people of Meru County elected a governor, and it is in their overriding interest that their elected representatives at the county assembly level, as well as their national representatives in the form of the Senate, only extinguish the people's choice and expression of their sovereign will for constitutionally permissible grounds that are proven to the required standard after a constitutionally compliant process. This public interest element necessarily requires that the adjudicative authority of the High Court be maintained and be seen to be maintained for the short period of time it would take to hear and determine the petition on its merits. Lastly, on the public interest, none of the parties opposed to the continuation of the orders in force have elucidated any unique or special circumstances at issue in the matter which are undisputed, and which would tilt the public interest against the petitioner's prayers. Consequently, it is my finding that the public interest favors the continuation of the subsistence of the interim conservatory orders in force pending the hearing and determination of the petition. Turning now to costs, noting the foregoing and the circumstances of this matter, it is fit, just, and proper that each party bears its own costs. Excuse me. Having analyzed the issues for determination, it is my overall finding that the petitioner applicant has met the requisite legal threshold for the grant of conservatory orders and for them to be confirmed and extended to the full hearing and determination of the petition herein, and thus the respondent has failed to satisfy the court to the contrary. For the avoidance of doubt and for the benefit of the members of the public who have been following this matter with great interest, the court is not saying that the petition will succeed or that it will fail. Rather, the court has found that in terms of the applicable law and legal considerations, it is fit, just, and proper for the interim conservatory orders in force to continue to apply for a little while longer. Paragraph 66. Ordinarily, a ruling such as this would end there, but there is a critical aspect that this court must plainly state. This court has repeatedly, in the foregoing paragraphs, and with respect to various limbs of the applicable legal criteria, expressed its position that it would be prudent and just to confirm and extend the orders in force for the few more months that it would take to hear and determine the petition. The court cannot, therefore, rest its pen before expressing clearly what that short period of time would be and what the obligations on the parties, and in particular the petitioner, would be. Paragraph 67. It is regrettably the case that in some instances, petitioners who are successful at the interlocutory stage in terms of receiving a grant of conservatory orders pending the hearing and determination of the petition, thereafter seek to delay the progression of the petition. They do so, of course, to benefit for as long as possible from those conservatory orders without reaching the point at which those conservatory orders may cease to exist, that is, the judgment date. This phenomenon has been the subject of much discussion in judgments in this and other jurisdictions, at colloquia, at trainings, in scholarly articles, and in both traditional and new media. What is clear is that there needs to be a balance of the competing positions and interests, so that in issuing conservatory orders pending hearing and determination of the petition, there is no scope for abuse of the court process or deliberate delay of the progression of the matter. To my mind, a court has two approaches that it can take in addressing this concern. The first is to issue a schedule with comprehensive timelines running all the way to the date of highlighting of written submissions. The orders confirmed and extended will then have to be confirmed and extended to a definite date rather than being open-ended, and the court would then extend them further to the judgment date it would issue at the conclusion of highlighting of written submissions. Such an approach would mean that the schedule and timelines would either be issued within the attended ruling or in separate directions that would derive their compulsive force from the ruling. The second approach would be to confirm and extend the conservatory orders for a specific period of time. The court would, in arriving at the period of time for which those orders should subsist, calculate the time needed for the various filings and milestones, culminating in the delivery of the judgment, with the judgment having the ability to bring those orders to an end if the petition was unsuccessful, even if the time for the same was yet to lapse due to the court having been guided by an abundance of caution. Paragraph 71. At this juncture, and before I articulate which route shall be applied in the present case, it is important for this judge to state that nothing in the conduct of the petitioner informed the proposed adoption of the above. The petitioner has been diligent in meeting all applicable timelines since filing of this matter on 21st of August 2024 to date, as have the respondent and the three interested parties. The petition and the petitioner's notice of motion application dated 21st August 2024 were filed on 21st August 2024. That means today's ruling is being delivered exactly 119 days from the date of filing of the initial application in this matter. Let me read that again. That means that today's ruling is being delivered exactly 119 days from the date of filing of the initial application in this matter. To arrive at this point, and having determined 4 other applications within the same 119 days from inception, could only have been possible due to the exemplary cooperation and diligence of the parties herein and their able counsel. Accordingly, each of the counsel in this matter is commended by this court for their diligence and professionalism in that regard. Turning now to which path the court will take, this court is minded to apply the second approach, and thus I shall in this ruling confirm and extend the interim orders for a defined period of time, which I shall formally pronounce under the disposition heading of this ruling. Disposition. Paragraph 73. Consequently, and for the foregoing reasons, this court issues the following orders. A. The petitioner applicant's notice of motion application dated 21st August 2024 is hereby allowed in the specific terms to be set out at paragraph C below. B. The respondent's notice of motion application dated 3rd September 2024 is dismissed. C. The ex parte conservatory orders issued by this court on 21st August 2024 are confirmed and extended for a period of 120 days from the date hereof, and in that time, the petitioner shall continue to serve as the governor of Meru County, with a proviso that the judgment in this matter may be rendered before of those 120 days from the date hereof. Due to the import of that paragraph, let me read it again. The ex parte conservatory orders issued by this court on 21st August 2024 are confirmed and extended for a period of 120 days from the date hereof, shall continue to serve as the governor of Meru County, with the proviso that the judgment in this matter may be rendered before the lapse of those 120 days from the date hereof. D. Each party to bear its own costs for the 2 applications. And finally, E. Directions on the hearing and determination of the petition within the period set out in C above shall be issued by this court immediately after the delivery of this ruling. Dated, signed, and delivered in open court on this 18th day of December 2024. I will then add the counsel who appeared in the matter.
Thank you very much, Your Lordship, for the lengthy but well thought out ruling, which we consider to be outside the box. We want to go on record as committing to comply with very stringent directions issued by the court, because we are committed to a timely and expeditious disposal of this matter. That is the reason why we moved the court to a certificate of urgency. We undertake to comply. Secondly, Your Lordship, is
Yes.
that subsequent to the filing of this petition, there were proceedings that took place at the Senate which have a bearing on this case. Unfortunately, the same came after we had crossed pleadings. We humbly seek leave to put affidavit just to annex certain answered reports to highlight certain utterances made by the Senate that touch on this matter.
Council Mutuma, my recollection is...
Yes, it has been filed, but without leave, so we can have the court deem the same as properly on record.
Mr. Mukele? Sorry, Mr. Mutuma, had you finished?
There is also an application for joiner. Unfortunately, the applicant was...
Thank you, and my apologies for interrupting. Yes, Mr. Mukele?
Indeed, thank you for that reason, really. I appreciate that it has taken the court's time to deliver the same, and we are grateful for that. And so, Your Lordship, on our part, we shall be taking the direction from our client. We shall be seeking for you to appeal that ruling. We shall also be seeking for certified of the proceedings and the ruling for this purpose. I think that covers that ground. As to Mr. Mutuma's request concerning a document, I am yet to see it. And so, Your Lordship, perhaps out of caution, I would want leave in the event it speaks to issues that are outside the scope to respond by way of an affidavit. With regard to the last issue of the application for joinder, I would still need to take instructions from the same. But I also understand that the County Assembly wanted to address this court. The lawyer is here. And perhaps I will end it at that level.
Yes, Mr. Kithure.
If I may, Your Lordship,
Yes.
my name is Morero.
Oh, sorry.
I'm not on the forum.
Yes.
I have another application to make on behalf of the County Assembly of Meru.
Yes.
There's an application for doing that in this proceedings, Your Lordship, pursuant to Rule 5 of the Mutunga rules.
Yes.
An application for joinder can be made at any stage of the proceedings.
Yes.
And therefore, Your Lordship, I honestly hope and believe that this is not an application that should be labeled in spot match. It is an application that can be determined summarily.
Yes, and that is what I intend to do.
Because the dispute at the Senate was primarily...
Council Mwereru,
Yes.
you have already won. You don't need to proceed.
Yes.
If you represent the county assembly from which the impeachment process started,
Yes.
there can clearly be no ground upon which a court can refuse. So I will join you.
Mr. Morioki equally intends to appear for the Speaker of the County Assembly. And also the move on the motion, Your Lordship.
So Speaker of the County Assembly will also wish to be joined?
The Speaker of the County Assembly itself, and the mover of the impeachment motion.
Why does the mover have a separate interest from the Assembly?
Because specific allegations, Your Lordship, have been made against the mover.
Couldn't he or she canvass the same?
It is best if she proceeds separately.
What is the name of the
Her
mover?
name is Zipporah Kinya.
Zipporah.
Kinya.
Please spell the surname.
Kinya is K-I-N-Y.
Yes. Thank you. So I can summarily allow those. I will formally do it at the end of my directions. The reason for the same is they appear to my mind to be very straightforward, and their voices are critical at the petition stage. Mr. Lawi?
My Lord, we would like also to thank you for the well thought out ruling.
Yes.
Listen to it. We think you have done a good job, Your Lordship. Similarly, in light of the direction that you have issued and the days that you have given on the part of the first interested party, we undertake to comply with the directions that the court will issue to the parties with regards to the filing of the responses and any subsequent pleadings for the expeditious disposition of this petition. That is all, my Lord.
Thank you, Mr. Larry. Mrs. Omondi?
And we'd be happy to get directions on how to proceed from here. And we also undertake to comply with what we understand.
Thank you, Mrs. Omondi. We undertake to comply with the timelines. That takes us to Ms. Nkatha.
Yes, my Lord. I would like to add my voice to those of my colleagues. And thank this court for the well thought of the ruling. We undertake to comply with the directions of this court in respect to filing of the responses.
The directions in terms of responses. Councillor Mukele, as stated in my ruling, I wish to give certain directions. Now I've lost the piece of paper, I'd scribbled them on, but I'd calculated the days. We would be done in 101 days from the date. I cannot deny you leave to appeal, but I wish to state clearly that today is the 18th.